Zoom, I have Jennifer on text messaging.
Welcome to the Franklin County Commissioners meeting, July 14th, 2020. We are ready to begin.
Thank you. We are here for our regular Tuesday morning Board of Commissioners meeting that for July 14th. I see we have Commissioner Didier in the conference room. Commissioner Peck and Cook are remote, and we have Keith Johnson and Karen Millam in the commissioner's room. With that, I'll call this order. And we'll start with the Pledge of Allegiance, please.
I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Well, the first thing to start with, obviously, nobody believes in the governor's emergency proclamation that was given him the authority by the four corners of the state and backed up by RCWs. So Commissioner Didier is sitting in the office, against those orders. So with that, we'll carry on to approval of minutes. We have June 16, June 23, June 30th.
Mr. Chairman.
Yes.
Chairman, this is Commissioner Peck. I apologize for the interruption, but if we're going to go down this road, then I want it to be with the full advice of our legal counsel so that everyone is aware and on the record as to what the consequences may be of violating the lawful direction of the governor. With that, Mr. Sant, I'm going to ask you if you would speak to that issue, and in particular, the question of whether or not actions taken by this board in a meeting conducted outside the law are in fact binding or subject to challenge.
Also, I'd like to add to that prosecuting attorney Sean Sant and civil deputy attorney Jennifer Johnson are on the phone at every meeting. So, thank you.
Commissioner Cook, and the board. I did send out a document. This is a revised AGO opinion that gives out guidance on the Open Meetings Act, and I sent that out so the board has that as a reference. That was just sent out earlier this morning. But basically, this is what we have previously referred to along with other review of the other proclamations. But I could sum up just real quickly because I think the question that the board's asking about are found under number 3. Previously, the proclamations have identified under the OPMA provisions and proclamations that in-person attendance by the public is prohibited. And so that kind of triggers an additional inquiry as to how does that relate also to the board. So if I could just read real shortly, question 3 of this document on the AGO's opinion that was revised March 26th, so following the first of the declarations following the pandemic, it issued, many governing bodies typically hold in-person meetings with most or all governing body members in physical or in-person attendance at the agency designated meeting office or other meeting room. On occasion, some members may participate or some members participate by conference call. The question posed is, can all governing body members participate by conference call? In response to this question, the March 6th guidance described that all governing body members can attend by phone. Revision. The proclamation language stating that meetings are, quote unquote, not conducted in person applies to the governing body members as well. Remember, the purpose of the temporary proclamation is to enhance social distancing and reduce person-to-person opportunities for virus transmission. This means board members will not want to place themselves or their agency staff in a position that potentially puts them in physical contact with each other in preparation for or during OPMA meetings. Such contacts could occur, for example, when staff are setting up a meeting room where some board members or the clerk would attend in person, or when board members attend in person, even if the public does not. It is possible many governing bodies, even prior to the proclamation, had already arranged for all governing body members to attend remotely during the outbreak in order to implement social distancing. And that's found in that AGO opinion, and that's part of the consideration that my office reviewed prior to last week's meeting. And actually, we've reviewed that months before as well and tried to give guidance. We just thought we needed to give that clarification for the board so the board would have that information. As to the other issue that's raised, it really depends. There's always going to be the potential for a challenge, but certainly if we go against violating some provision of the Open Meetings Act, that does place in jeopardy any actions that took place during the meeting. So I would just urge the board to use caution. This is my guidance. My job is not to see how close we could get to the edge of the cliff. My job as your legal counsel is to keep you as far away from the cliff as possible. And I believe that this is the concurrence with you could see it with other counties, where once counties move into the other phases, 2 and 3, additional allowances are provided. And that seems consistent that when they had to revise this to accommodate counties in phase 3, that can accommodate larger groups, but they are still limited, and there still has to be, even once we reach phase 3, we'll have to make sure that we provide accommodations for people to still attend or have an overflow area or others so that the members of the public can fully participate.
So Sean, this is Commissioner Didier. Technically, we're still in phase 1. What is the limitation of people in one room on phase 1?
Phase 1, we're not supposed to have any public gatherings. There's 2 different things. We shouldn't be having public gatherings except for those within your immediate family members under the existing proclamation.
So then,
public meetings like this, even small groups are prohibited under the other proclamation language.
So then we're out of compliance with Keith and our clerk of the board in the room if they were here by themselves. No, because there's a special accommodation that provides that such limitation on staff to facilitate the start of the meeting, the recording equipment, all of that is provided for them to be able to do that as well. But a county commissioner can't sit in the room 10 feet away from the administrator.
I get it. Again, Commissioner Didier, I'm not trying to say, does it all make sense when you look and review the whole proclamations about the occupancy in a large box store versus the small business? I get that. I'm just trying to give the board the guidance that we've reviewed as far as what it says. And I'm trying to make sure the board has that understanding. Again, until that provision is challenged somehow, we're trying to do the best we can to be in compliance. And I'm trying to give all of you the best information that me and my office has discussed ever since these happened. I mean, these things change rapidly. We had last week the extension by the Four Corners, so now that goes into August. And so we're just trying to keep up as well, and I'm trying to give the board the best information as it changes. I'm hoping that perhaps once we get into the next phase, that might allow us to have some additional members, and we may be able to have in-person board meetings, but not members of the public, I believe, until phase 3.
Because I sent you an email and your communication back to me was RPC 4.2, communication with person represented by a lawyer. I said I was getting consultation from a lawyer, and you didn't give me any written review on your opinion on this. So I looked it all up myself, and I went through it, highlighted it, and I don't see where I'm out of compliance from being in the room.
Well, like I said, I just referenced the AGO opinion, and again, regarding your contact, the contact was specifically on a specific subject matter, and you said your attorney was requesting it. And so what I did do is I responded and I said you could have your attorney contact me to either authorize me to have that specific subject matter discussion with you, or that would allow me to have a discussion with your counsel. Once counsel is put on notice that a party or a person is represented on a particular subject, that takes me out of the picture from being able to communicate with you on that particular item. I realize that probably doesn't make a lot of sense to a non-lawyer, but for us lawyers that have to follow the rules of professional conduct or jeopardize our bar license, I'm going to adhere to that just like any other law. And so I have not heard from your attorney. He did not reach out, or she did not reach out to me yet. And so I'll be more than glad to share this. I have shared the AGO opinion, Commissioner Didier. I apologize that particular document was just sent out earlier this morning, but that has been the guidance that we've been providing to the board. And I would assume that the board obviously knows that we do a quite considerable amount of research before we give the board an opinion, and that's making our best determination of our reading of all the rules, opinions, legal opinions, case law. We're trying to give the board the best information that we have. And this is a very new and dynamic situation. It is constantly changing, and we will continue to do the best to provide the board updates as we need to do.
Okay, because I've asked for your consultation on other items in the car tab issue and the redistricting, both of which obviously the outcome was different from your advice. We had Pierce County represented in the car tabs and the redistricting. You know, I mean, we got the cart in front of the horse. We didn't put the bilingual out there. So Sean, I'm not being critical of you. I'm just saying that your advice that you gave me before was incorrect. So I'm feeling pretty safe that we're going to be able to have a legitimate meeting here, and there won't be any reprimanded actions to the county. I am social distanced away. I'm in the meeting room, and I'm just trying to give our county a sense of normalcy by seeing somebody on the camera willing to step into this, I guess, this dangerous environment to give a sense of calmness and conduct a meeting like we used to, getting back to some normalcy.
And just with all due respect, Commissioner Didier, I'm not sure what you're referencing as to any kind of legal opinion or advice on the car tab issue or otherwise. I think I clearly stated to the board that that is a direct responsibility of the Attorney General's office, and they have been doing a good job by your own words. And that's what the Attorney General's office is tasked with, is defending initiatives. And they, to my knowledge, they have done a great job in defending that, as they have on other initiatives. Guidance given on the redistricting effort, I'm not sure what exactly you're referring to as far as an opinion, because those discussions occurred prior to the COVID outbreak, and because of the COVID outbreak, that kind of put a halt on a lot of things, and a halt on the opportunity to be able to do that in a timely manner prior to the filing period. And I think, in all due respect for all the other potential candidates that were considering participation, if you were to do a redistricting after filing week, I think that would be definitely challenged. And I think the board basically concluded simply waiting until after the results of the census. At the point when we couldn't do it, we couldn't legally hold that kind of public meeting and participation on that issue prior to the filing week in light of the COVID restrictions. I think it just kind of naturally took its place, and that's going to come up probably with the results of the census now at this point.
It was the fact that you said that we would be sued on both of those. If we were to,
on both of which,
on the car tabs and the redistricting, you said we would be sued. There's a potential of lawsuit if we were to engage in a lawsuit on the car tabs. Pierce County was there. There was no lawsuit against Pierce County.
I never said that we would be sued if we engaged in it. I said it's not the job of Franklin County to address that tab issue.
Oh, I do remember you saying there's a possibility that we could be sued on both of those situations, but we are into the Tules now. We're back to the meeting, and I don't think I'm in violation. I think we should continue on, hold the meeting, and get the work done for the county.
And just, I guess I'll just conclude with this. One of the advantages of following the advice of legal counsel for the county, even as you say, if you believe that we are wrong and we're giving you wrong advice and guidance, that gives you individually and collectively as a board, that gives you the protection that you were following the advice of counsel. If you choose to ignore our counsel, that's fine, but that's up to you, and that's, you know, there's a natural consequence that comes later. That could jeopardize our risk pool from being able to defend actions against the county. It could possibly put the commissioners having to retain their own counsel, because that would be acting in a scope outside of their work if they're going against legal counsel. And so you might have to retain your own attorney to defend actions that might come against you. We're just trying to do the best we can to protect the county as a whole.
I appreciate
and
that.
Litigation costs money, and I've treated litigation as the taxpayers' money. It's the people's money, and I'm trying to do my best to keep our county out of legal jeopardy with as minimum cost to the people's money as possible. If I could only advise, I have no action. I have not been elected to take those executive decisions that the board has, so I'll just defer to the board.
And
Thank you for giving me the opportunity to speak. Thank you.
And I take full responsibility for my being in this commissioner room.
Well, that doesn't help the rest of the board a bit, though. So, and with some decisions that are coming up with signatures needed, we can't move forward with the advice of our attorney.
So again, you're going to make me remove myself and go down to my office, where last week I wasn't able to get into when you asked if there was any more for the good of the board, and I tried to pipe up, and you just ended the meeting directly, and I missed an opportunity there for something at the end of the meeting that I wanted to talk about. And I don't think this is the way to conduct meetings, quite honestly.
I totally agree with you, but it's not our decision.
This Opens Meeting Act, I don't see anything in here that says I can't be in this meeting, even with this proclamation on it. There's nothing in here that says the commissioners cannot attend the meeting.
It carries on and talks about no in-person meetings.
Well, we got two people in person. We got the clerk of the board and the administrator.
You explained why they were in there. They were needed to handle the AV and the phone. They're required to be in there.
Well, for the good of the county, I guess I will remove myself back to my office again. But until, as we heard from Sean Sant, until somebody challenges this, we're going to continue on this path. And I would hope that Franklin County would have the nerve to challenge it. But I guess we don't. And that is a sad situation.
I appreciate your decisions. We'll go into recess for 10 minutes while you can get set up downstairs.
Mr. Chairman, this is Keith. I may just ask for a clarification at the end of the meeting when you ask if there's anything left for the good of the board.
Give it more time.
That you receive an affirmative response from each commissioner before concluding the meeting.
I agree. Thank you.
All right, go ahead.
All right, now I see we're back, so thank you for the recess. Can everybody hear and see Commissioner Didier?
Yes, I'm here.
Hey, Commissioner.
I'm here.
Thank you.
Back.
So we're back into a full board remote. So thank you all for putting up with this. I understand there are some phone calls in queue that we maybe would take, so don't keep them on forever.
Yes, Mr. Chairman, if I may, I received a written comment from an individual who is not able to attend in person. Perhaps I could read his brief comment into the record and then take the phone calls.
Thank you.
Okay. This letter comes to us from a Mr. Justin Carey in Pasco. It says, Mr. Johnson, thank you for your service to our county. I appreciate all your hard work. I am unable to call in today, but have noticed that you read letters from citizens in place of a call in the public comment section of the meeting. I wanted to express my support for Commissioner Didier as he stands firm for the citizens of this county who want truth and information from the health department and in his defiance of the governor's clearly unconstitutional mandates. All American citizens are endowed by Almighty God, the Creator, with rights, some of which are expressly stated in the Constitution and Bill of Rights. Most notably, in the current situation, we have a clear violation of the separation of powers. Governor Inslee, as you know, is the executive branch. He does not make laws. The Washington State Legislature, who makes the laws, isn't even in session. All of his orders past the original 30 days are unconstitutional. I would offer that pressuring Commissioner Didier out of the meeting on Tuesday was the unlawful action, and such action could void or invalidate the actions of the commission because unlawful dictates by the executive branch are being followed. I would also add that Commissioner Didier and all of the citizens of Franklin County's First and Fourth Amendment rights are being violated with any further lockdowns or no mask, no service mandates. You had it right you had it right a few weeks ago when you declared Franklin County open. Please do so again. You can lead Washington. Sincerely, Justin Carey, Pasco.
Thank you for your letter.
Our first caller is on the line. Just wait for the transfer of the call. Good morning, Mr. Lowe.
Yeah, can you hear me?
Yes, sir. Please make your comments. You have 3 minutes, please.
Okay. Well, the flow of the last meeting made me realize how easy it would be for one of the commissioners to have the power to control the meeting using private communications behind the scenes through text messaging with other members of the meeting. While this may or may not have happened and may or may not be illegal, it is certainly unethical. 3 commissioners in a large boardroom would certainly fall below the qualifications of a gathering of 5 or less people and would show a level of transparency we have not seen lately. At the very least, I would think that we would have the technology in Franklin County for each of the commissioners to be live streamed using their webcams from their computers so that we can actually see facial expressions and see what their hands are doing while their mouths are talking. I think that we deserve that level of transparency in Franklin County. Also, I cannot be convinced that this virus is discriminatory between small businesses and big box stores. And I think it's time for this county to become a nationwide leader and say that either the big box stores have to abide by the same rules as the small businesses in our county, at least at a county level, or say that if the big box stores can operate under the guidelines they're operating under, we can have our small businesses operate under the same guidelines. Either way, we're picking and choosing winners right now, and that is not fair. And that's pretty much all I've got to say today.
Thank you, Mr. Lowe.
Have a good day. I got to get back to work.
Thank you. We do have a second caller. Good morning. Is this Ms. Hatch?
Yes, this is.
Good
So
morning.
I am, oh, let me turn down my volume just a minute.
We're getting an awful lot of
Okay,
feedback.
there we go. So, I am calling in for a couple of things, so I don't have the, since this, AG, report that Mr. Sant has that he didn't make public, I, am operating a little bit blind here, and I think that was, kind of, disrespectful to Mr. Didier that he just now gets to see that this morning. I also believe that most of this should have been held and dealt with in an executive meeting, but the fact that you guys wanted to perform your little skit last week was humiliating to Franklin County, but mostly to yourselves. And I want you to know that you all look weak and inept. First of all, the meaning of meetings, that was something that Commissioner Peck said that having a meeting is an action. If you look under the Open Meetings Act, under RCW 42.30.020, it gives the meaning of meeting. It says meeting means meetings at which action is taken. So there is no, having a meeting in itself is not an action. You have the action at the meeting. So that was the first point. But the second point that I have is that, you know, every time we come and we have a discussion, and there was, I do believe that Mr. Sant was incorrect in the redistricting because the law clearly states you can't redistrict after election. You can only redistrict in an election year the day after election the year before, and I believe it was January 16th or 20th, I can't recall offhand. But that is the law. And you guys were trying to do it in February. Plus, it also, another RCW said not in an intervening census year. So that was a double whammy of why we could not redistrict. But besides that point, another thing that you guys did illegal was you raised your salaries without a salary commission. And maybe that's legal. Maybe you can get by with that in court, but it's really corrupt. And second of all, a salary commission is really important because it really addresses what our county can afford. And our county is the third poorest county in this state. And yet you guys pay yourselves almost as much as Benton County commissioners that are the 10th wealthiest. And a salary commission, which is appointed, there's legal ways to do that. That has to be done correctly. And as well as a redistricting commission. There are certain people and certain types of people that are and chosen by certain people that have to be on that redistricting commission. Who are the people on that redistricting commission? Please name names, because as far as I know, it was Commissioner Peck and a few other people, which again is illegal. He's not supposed to be on the redistricting commission. But maybe if you guys didn't spend all your money on raising your raises, then maybe you could afford fighting actually in court for the people of Franklin County. And that's what we expect from you. So what I see right now is a bunch of cowardly men and one man that's willing to stand up for the Constitution, which you all swore an oath to, not to uphold unconstitutional laws, but to uphold the Constitution. You guys are failing in your oath of office. Thank you.
Thank you, Luanda. Okay. All right, we do have a third caller on the line. Good morning, Mr. Robinson.
Well, hello, Keith. How you doing?
Good, thanks. You are on the floor is yours for 3 minutes.
Well, thank you. I'm a little excited. I've never tried calling into one of these before. Hello, fellas. I hope everything is well. I'll be brief. First of all, as a citizen of Franklin County, it is deeply concerning and disturbing to me when I see what appears to be one of my county commissioners mercilessly targeting a co-equal branch of our county government, namely the prosecutor, and implying that he's not good at his job. You have no evidence of this. He's followed the law. If you have a problem, file an ethics complaint and be done with it. Do not subject the public to constant ridicule of the prosecutor. It's unprofessional and it's ridiculous. Second of all, you need to follow the law. If you're in the room, you're screwing up and it needs to stop. I will tell you as a concerned citizen, if it continues, I'm going to start looking into my options to challenge the validity of these meetings because I'm not going to let this county continue to be humiliated by asinine or otherwise unpleasant behavior. And third of all, Commissioner Cook, thank you very much for holding the line on this and making sure that we lower our liability by making sure that we are following the governor's order. I know it is not easy, and I know that we may disagree politically, but I do want to commend you, sir, because I feel like you are doing your job as the chair of this county commission, especially in reference to this, and I just wanted to make sure that you got some validation. And finally, I don't think it's very appropriate for people to be calling the commissioners cowards in a public comment like that. I think it crosses over the line, and I think that we can do better in terms of the dialogue. I would appreciate it if in the future when somebody starts resorting to personal attacks, even if it seems like it's me, if we maybe shut that down. Because frankly, it's not okay, it's not appropriate. These meetings are seen by lots and lots of people, both in the county and outside the county. We have to start modeling the kind of professional and effective behavior in our government that we are asking the state level government to perform, the Congress and the presidency. If we can't do that, why on earth are we here? Thank you.
Thank you, Mr. Robinson. Mr. Chairman, we have no other calls at the moment.
Thank you. Thank you for catching us up there. So with that.
Mr. Chairman, Commissioner Peck.
Yes.
Now that the calls are complete, I think it might be beneficial to the record and to those listening. It's very easy for people to unintentionally or otherwise misunderstand or miscommunicate specific terms and language. A review of last week's meeting will show that the comments about what constitutes a meeting or an action, what I actually said was that a quorum of commissioners discussing issues, the discussion constitutes an action under the law. I did not say that meeting is a violation. So the point was that the action is not the meeting. The action I was referring to very clearly was a discussion of issues of official business by the board is an action, whether a vote is taken or not. Thank you.
Okay, thanks for the comment. And say with that, we'll get back to our approval of minutes. As I started to say, in June 16, June 23, June 30th, and July 2nd. If there's no additions or changes or corrections, I will sign them as presented.
Mr. Chairman.
Yes.
This is Commissioner Didier, and I have on June 23rd Commissioner meeting minutes, I have a bullet point that states Commissioner Didier asked Mr. Johnson about the travel vouchers and how this matter was resolved. Mr. Johnson replied that Commissioner Peck reimbursed the county for travel and was taken due to unclear travel policy language. Now, I take offense to that because back when this policy was written, before I was a commissioner, Commissioner Peck was then the chairman and wrote the policy. So if he doesn't understand what he's writing, I take offense to that. Commissioner Peck also clarified that he saw the mistake and made every effort to correct the problem. Again, that is an untruth. I asked for a policy request on the travel. And when I received it, I gave it to the ASO, the state SAO, the state auditor's office. They came back and were not willing to do anything. And until a private citizen got involved was when the money was repaid. So I have a big problem with this statement, the way it's written right now in the minutes.
So how would you correct it?
So, Mr. Chairman, Commissioner Peck, the simple solution in these matters is to do a verbatim transcript of that portion of the meeting. The meeting minutes are to reflect what was said in the meeting, not what somebody's opinion might or might not be. So I would advise that the correct solution is simply do a verbatim transcript of that portion, and that gives an absolutely clear, unequivocal reflection of what transpired in the meeting. Again, that's what the meeting minutes are to reflect, not people's opinions.
And I completely agree, because I brought up the fact that the emails were exchanged in 2014, where Julie Jordan sent an email to Commissioner Peck saying, "Good afternoon, Mr. Peck. I'm going over your travel voucher for your trip to Vancouver, and I have a quick question. Resolution 2012
Mr. Chairman,
indicates
point of order.
reimbursement of the official travel mileage go beyond 50 miles. Has this been deducted from your mileage?" He sent back a response. "Thanks for asking. I have spoke to Matt Beaton on Friday expressing concern that I could not recall if I had deducted the 50 miles. I'm concerned that I may have forgotten to do so. The mileage should be approximately 320 miles. This was in 2014, and he continued to take this until the present day when he paid it back."
Mr. Chairman, we're talking about meeting minutes. If Mr. Commissioner wants to make this a separate agenda item, he can. It's pretty apparent what's going on in this election cycle. But right now we're talking about the minutes. I'd like to see resolution on that, and then we can move on.
Okay. So meeting minutes for June 23rd, you're asking to have verbatim.
Please, yes. So we need to pull them until next week.
Pull that one.
Yes, the 23rd.
Mr. Chairman, I would propose that they can be approved on the provision that section be transcribed verbatim. I don't think we need to delay it a week, but if you want to, that's fine too, whatever.
I want to delay it a week, Mr. Chairman.
Okay, that's fine with me.
Chair, this is Clerk of the Board, Karen. Asking for clarification to have verbatim just on that particular subject, correct?
That was just a suggestion I made. I'm okay with it. We have a recording of it. If people want to know exactly what was said, they can listen to the recording as well, but I'm fine with a verbatim transcript. It'll be apparent.
So what do we decide? You want just that item?
Yes, sir.
Yeah, just that section is fine.
Okay. Karen, you have the direction?
Yes, sir, thank you.
Okay. So with that, we are going to approve June 16, June 30, July 2nd.
Yes.
Okay, I will sign them as presented then, and we'll hold off June 23rd until further discussion. Thank you. Public comment, do we have anything else, Keith, on the line?
Not at this time, Mr. Chairman.
Thank you. With that, we will move into paying the bills.
All right, Mr. Chairman, we have two fiscal items this morning. The first is salary clearing and emergency management payroll. Move for approval as presented in a total amount of $972,915.28. And note that this was reviewed and signed off by two members of the auditor's office.
I second.
All in favor?
Aye.
Aye.
Aye. And second of two items this morning is fund expenditures. Move for approval of fund expenditures as presented. Total amount $383,119.95. Note that this has been reviewed, signed off by the county administrator and two members of the auditor's office.
Second. All in favor?
Aye.
Aye. That brings us to the consent agenda, 1 through 3.
Mr. Chairman, I'm looking at, agenda I printed out that's only showing 2 items. Are there 3, and was this agenda updated and maybe not posted?
It was posted, let me bring it up again.
Mr. Chairman, if I may, there was a additional consent item that had been submitted by one of our departments that was not included on the first published agenda, but the clerk updated that, I believe, yesterday to inform the commissioners that that additional item had been added. It was.
Yeah, Mr. Chairman, I just pulled it up online, and I'm aware of the third one. I read it in the read aheads, and now I'm looking at the updated online version. So with that, I move for approval of the consent agenda as presented, 3 items.
I second.
Okay, any discussion? All in favor?
Aye.
Aye. That, we'll go on to, Keith, still nothing on the phone?
Yes, sir. No calls at the moment.
Okay. With that, we'll moving on to your office business, please.
Okay, thank you. The first item, I want to have a brief discussion just about the status of the CARES Act funding. You will recall that I believe it was last week we signed the agreement with the Department of Commerce that would ultimately release those funds to Franklin County in the amount of $5,207,400. We have received some preliminary information from the departments and agencies in Franklin County that would be requesting additional funds for the expenses related to their response to COVID-19. That would include additional equipment, technology, personal protective equipment, those kinds of things that have been necessary but were not budgeted at the beginning of the year, that would fall under the approved guidelines for CARES Act funding. So while I am awaiting for final signature from the Department of Commerce on the agreement, I just want to inform the board at this point. It's not asking for action. I will ask for that official action when we have received the signed contract back from the Department of Commerce. But there are some assurances that various groups need to make sure that they're going to be reimbursed for these expenditure items. There's a list of about 7 items that I want you to be thinking about. Welcome to discuss or answer questions that you may have about those items. They range from, I'll just kind of walk through the list. The juvenile justice system over in Benton County that we share with Benton County had some additional technology upgrades to allow their case managers to work remotely, as well as the PPE equipment and supplies that they needed for running their facility. It's a total amount of around $30,000 that we will be expected to contribute to that function. We've also recognized that there's a number of technology upgrades that we've needed here in the courthouse, particularly related to the jail and the court system. That comes in at approximately $150,000, and I'm being a little conservative in these numbers to anticipate that we may have some things that we haven't seen yet, but want to make sure that we have adequately protected the county's interests. The county itself, independent of those technology upgrades, we expect somewhere in the neighborhood of $100,000, again, for PPE and other modifications to offices and things that have needed to take place to accommodate our COVID response. The largest amount is expected to come from or go to the Benton Franklin Health District for their additional COVID response costs. I have a preliminary spreadsheet that they expect their total funding gap after they have considered additional state disaster response funds and federal FEMA funds to come in at about 3.2 million, almost $3.3 million in total. If we anticipate that Benton County will pay their traditional approximately 70%, and Benton County, or Franklin County, excuse me, Franklin County pays our approximately 70%. That would put us somewhere in the neighborhood of $1 million going to the Benton Franklin Health District to provide their additional costs. Then I left about a $90,000 contingency amount in there for either these groups or others that we are responsible for that may have expenditures that they have incurred. And that leaves a remainder available of $3,927,400, and that's an approximation. But that I believe, or my recommendation to the board would be used primarily for economic recovery in Franklin County, and it would be directed toward programs that small businesses, maybe medium-sized businesses, could apply for to offset some of their economic impact of the shutdown that has taken place over the last few months. As you're well aware, this COVID pandemic has continued. It's expanding in some areas. Franklin County and Benton County both have much higher transmission rates than we had expected. So these estimates of expenditures are more than likely to increase rather than decrease. So I don't want to overcommit these funds. It's a very delicate balancing act between making sure that we're utilizing as much as we can to benefit the economic recovery of the county, but not put us in a position where we can't honor commitments and necessary expenditures for these items. So again, I'm not asking for a decision at this point. There are a couple of decisions related to this that we've had to incur those expenses, and I've given somewhat tacit assurance to these groups that Franklin County will participate and meet our obligations to our fair share of these expenses. But I realize that without a formal board decision, I can't completely authorize that. So I just wanted you to be aware of that. I'm certainly happy to answer questions that you may have. I think because of the nature of this, it's important for the public to be aware. So I wanted to bring it up in a board meeting to let the public know kind of what we're doing and planning. And hopefully this will be a substantial amount of money that will help us deal with the extra costs that we've incurred as a result of our response to COVID. So with that, maybe I'll pause and see if you have any questions or comments regarding that.
Mr. Chairman, this is Commissioner Didier. Keith, the question I posed last week is on the 2020-146. It says financial impact, $5,700,400 is available from Congress to offset the direct costs incurred as a result of the COVID-19 pandemic. Again, you stated that we're only talking about 5.2. What is the discrepancy between these two numbers, and why is it $500,000 off?
That is a typo.
Which one? The 5.7?
I believe the 5.7 is the right number. The higher number is the right number. Where are you reading that from, if you don't mind asking?
It's dated July 6, 2020, prepared by Keith Johnson.
Yes.
This is
Okay.
the 2020-146 that was in our booklet last week.
Are you reading from the resolution itself or the ASR?
The resolution itself.
Okay, the resolution has the correct number in it. The ASR does not. It's 5.2? Yeah, thank you.
Oh, this is the ASR.
Yes, the ASR had the typo in it. The correct number is 5207400. So thank you for correcting it.
Okay.
Further questions? I don't hear any, Keith. Thank you.
Okay, thank you. The next item is a couple of weeks ago, we discussed the possibility of engaging a communications contractor to help us set up social media accounts for Franklin County, particularly like Facebook and Twitter and possibly Instagram. I've been in contact with about 4 different companies that provide these kinds of development services. They have responded with some proposals. They're not exactly equivalent in that the services that they offer are a little bit different. Their areas of expertise are a little different from a technical standpoint. Each one of them could provide the basic Facebook account, getting set up, social media account set up, but then they differ a little bit in their levels of expertise in terms of what they focus on in their companies. The 4 companies that I spoke to are Focal Point, operated by Derek Nelson. They've done a considerable amount of work for Benton County. Very competent firm, does a lot of good things. Another company called Art Mill, run by Dennis Miller. They've done quite a bit of this digital work for TriDeck and for the ports. A company called Stevenson Advertising, managed by Kathy Balcom. And then the Tri-Cities Public Relations, that is managed and owned by Mike Paoli, who we have briefly discussed before. Mike has done work in the area. The one advantage of Mr. Paoli's firm is that he has recently been engaged by the Benton Franklin Health District to do this kind of work for them. And considering the fact that our biggest need right now is to communicate better information regarding COVID and the county's response and what we need to do as a county to engage the public, my recommendation to the board is to authorize me as the county administrator to begin a negotiated contract with Mr. Paoli to sort of get the benefit of economies of scale by the fact that he's already going to be doing this work for the health district. And we want to be consistent in our messaging across the Tri-Cities community, particularly obviously in Franklin County. The distinction in price was not material enough to make a significant difference. I think any one of these firms could basically do the basic work that's required, but this is really within Mr. Paoli's wheelhouse in terms of public relations. And so that's my current recommendation, but certainly would stand for questions. If the board members would like to individually review the proposals that were submitted, I'm happy to provide you with those. I do recognize that the time is of the essence, that we do need to move on this sooner rather than later, but I'm happy to whatever the will of the board is.
Well, Mr. Chairman, this is Commissioner Didier. After this was proposed at the last meeting, Auditor Matt Beaton came in and spoke of a conflict of interest with Mr. Paoli and his relationship with one of the commissioners on the board who is running for election. I would have a very difficult time voting for Mr. Paoli because of that.
And I don't understand, I guess there's 2 other commissioners on board. That's one that has a knowledge of Mr. Paoli. I don't have a knowledge of him. Do you have a former knowledge?
I don't know.
Okay. Well, I guess my first suggestion would be to look at the rest of the applicants and have a better understanding of the consequence. So
I agree. I think we should all review all the applicants and make a good decision then.
because I don't want to just knock one out just because, you know, one of us has met the person. So, Keith, if you can help us. Yes?
Yeah, Commissioner Peck, no problem with the recommendation to take time and look at all of those. I think that's good process. No issue there. I would ask the board to consider that the most important part of the work that we're seeking to have done is not the mechanics of setting up these platforms, but rather developing the content for those. And that's where experience and messaging and communications expertise really comes into play. I'm not making any judgments about the capacity of any one of the four to do that. We'll each make our own judgments by reviewing those packages. But as someone who has done this work for decades, it really is about the content, not just setting up the platform. So thank you.
The other thing, Commissioners, if I may add, is the level of staff time that would be required to monitor and respond to comments that are received in a social media engagement type of atmosphere. I support the idea. I think it's important for transparency and to get better communication with the citizens. I will tell you that having the time to read comments from citizens and respond to those directly is going to require additional staff time. How much, I can't say, but it is a bit of a burden. And I'm not saying that's a reason to not move forward with this. I think we need to, but I just want us to be aware that that will be the case.
Yeah, thanks for the forewarning, but I would have expected that you know, we don't have an overabundance of staff as we speak. So thank you for that observation.
The last item I have today, unless you have questions on that subject, is a discussion on the Happel Center COVID-19 testing site that was set up by the National Guard on behalf of the Benton Franklin Health District. All indications are that has been very useful. It has been very helpful to the community in identifying new cases and working toward the contact tracing that's required. I will state for the record that the National Guard has done an excellent job in being professional and being cooperative in our interactions with them. However, last week it became a news story before anybody knew about it or could respond to it, that there was a request to perhaps consider moving that testing site from its current location on the kind of the northwest parking lot area to a different location somewhere around the Happel Center. I will say that is possible that we move it. It's not my preference, but the reason the question came up is, as you know, the public mostly knows that right in front of the Happel Center front door area are some utility payment drop boxes, as well as the ballot box for the upcoming elections. I understand after talking with the county auditor, who is in charge of the elections, that is the most used drop box in the county. And it's important that voters have complete unfettered access to that drop box so that they can place their ballots in there. When we initially had this discussion with the National Guard, they were kind of wanting to be in a location that would have required more or less a walk up to the ballot drop box rather than being able to drive by. But we have since relocated them a short distance away from that front door area. And now there are essentially 2 lanes of traffic. The COVID-19 traffic goes into the northwest parking lot and turns away from the track or the Happel Center building out into the parking lot and then departs after the testing has taken place. And the lane that comes up directly to the Happel Center, that is a separate traffic lane, is unblocked, unfettered, and they can drive right up to the ballot box, not get out of their vehicle, put the ballot in the box or their utility payments in for those that are coming in for that purpose, and drive away. At times of the day, there are some significant lines for the COVID testing now that it does not require any appointments. The National Guard does shut down at 2 o'clock every day. So those that want to drop off their ballots after 2 o'clock in the afternoon, there's no line of traffic or no reason to be concerned about access to that ballot box. But because of the question coming up of that location, I spoke at length with the lieutenant out there. They were willing to move if needed. Spoken with Tom French, the manager of the Happel Center. We can move that testing facility if necessary. My concern with moving it to perhaps the back side of the building or some other location on the center, they have seen the line, they have seen the fact that the testing is going on. And if we relocate it, those that come in for testing may feel like it is no longer operable or is not up and running and may drive away rather than stop and get tested. The counter concern that I think has some need for discussion also is the appearance for those who are dropping off ballots to have to be in somewhat close proximity to those that are being tested by driving in the same parking lot. I personally have not determined that I felt like that was a particular problem because the National Guard's people are directing traffic. They have cones set up and signs set up to direct people to the right location. But if that is a serious or legitimate concern, then there could be something that I'm missing in terms of them both accessing the parking lot. So long and short of it is, I think the staff of the Happel Center and Benton Franklin Health District and my staff could have resolved this, but there's certainly some other questions of things that I may not have thought of or that we may not have adequately considered on behalf of those who are concerned about access to ballot boxes and voting rights. And so I felt that it was important to elevate this to a discussion amongst the board members. There are, political connotations to this in terms of access to ballot boxes and the nature of current elections. So I want to defer to the board's judgment on whether they think we need to relocate the COVID testing tents or if what we have proposed and we're doing now is sufficient. So that's kind of a long-winded explanation, I realize, but I hope I've given you the appropriate details to make an informed decision.
Mr. Chairman, Commissioner Peck.
Yes.
Just a few thoughts here I've been jotting as Mr. Johnson was speaking. Excuse me. The addition of postage paid on ballots this year effectively turns a ballot drop box into your mailbox. While I realize there will still be some people who will use that drop box, I think it will be far fewer than in the past, since literally you can drop it in your mailbox, postage paid, and it'll be taken care of. Second, I don't know what the schedule is for Takaha and the use of the ice rink around the other side, but we potentially create some conflicts by moving it to the back of the building. Thirdly, without getting into specifics and turning it into some kind of a debate, I'll just say that there is a public record statement from a member of the National Guard concerning activities involving a commissioner out there at the Hapo Center started a lot of this. That's unfortunate, and I think at this point we should be sensitive to trying not to further erode our credibility and relationship with the Guard. And then lastly, I would say, all things considered, it seems to me that a reasonable, common sense compromise would be simply to ask the Guard to move when I say Guard, I mean the National Guard, ask them to move the testing activity further from the ballot drop box, but still in the same parking lot where it's visible, so that people who are accustomed to knowing where it is due to all the advertising about it when driving up to the area can see that it's still there, and we can provide additional separation between the ballot box and the testing to ease any concerns from those few people that may choose to drop it there instead of in their own mailbox. I think that's an accommodation that speaks to the concerns of all, and is my recommendation. Thanks.
Mr. Chairman, this is Commissioner Didier.
Yes.
Yes, I received some phone calls from some concerned citizens, so I drove out there to take a look at it myself. And as I drove up to the site, away from their test site, I did get out of my vehicle to take a picture of the drop box and the close proximity of the hazmat suits that were dealing with the testing. Upon getting out of my vehicle, standing on the grass of an island away from the National Guard and everything else, I was approached, and the military command and control, I was shouted at of what I was doing, and I said, it's obvious, I'm taking a picture. And then I was told that I had to leave immediately, and if I couldn't be by that drop box that close on an island of grass, how was a voter going to be there, was my first thought. I have concerns about the mail, and the mail is not that dependable anymore. I've had checks disappear out of my mailbox, brought back as evidence. I've had people complain because they mail their ballots 2 days before the deadline, but it's got to go all the way to Spokane and back, and their vote doesn't count. I think the drop box is the most adequate place to be dependable on getting your vote counted. And I agree the test site should be moved to the west side of the parking lot, where it is completely visible from anybody coming into the Hapo Center and away from the front of the Hapo Center. This is a logical place, and they could go right up a line there, a straight line, drive in, make a little bit of an S-turn, go straight up, get tested, make a loop, and head right out. And I think that's the place it needs to be. But after this all transpired, within an hour, this was on the news. And I was curious of, I wanted to get these pictures to bring it up for discussion at our meeting about this location. And within an hour of my presence there, it was all over the news that I was saying that testing doesn't need to be done. I never said that. In fact, I want the people to know I was tested for the antibodies because I believe I had this in February. But then after all this transpired, I got this email from Matt Beaton, the auditor, and the auditor's office, Jeff, was already all over this, and it is already scheduled to be moved. So it is, I say we just let their plan take place. They're going to move it further away from the building to the west side of the parking lot, and everything's good.
Okay. So what is the recommendation of the health district and you, Keith, and
Yeah, I've spoken to Jason Zakaria over at the health district. They are willing to move if that's a recommendation. The National Guard has expressed a willingness to do so. So I think if that's the will of the board, we can find a way to accommodate that. I do agree that moving it back to the ice area is probably not ideal. The ice hockey season doesn't really start until August, but we also recognize that ballots are coming in first part of August. So even though it wasn't really scheduled to be moved, it will be moved as needed.
Well, I think that's the best of both worlds at this point. So, can we get that accommodated?
Yes.
All right. Any further discussion? Do you have any comments on the phone?
We do have, yes, we do have, looks like one caller on the phone.
Okay.
Excuse me, it looks like we have two callers on the phone.
Okay, we could go ahead with that, please.
The test site should be
Good morning.
moved to the west side of the parking lot where it's completely visible for anybody coming into the Hapo Center and away from the front of the Hapo
You need to
Center.
turn your speaker off.
Lawanda, can you turn your speaker off? Thank you. Go ahead, you have the floor.
Are you talking to me?
Yes.
Oh, okay. Sorry. Just in this testing situation, first of all, I mean, simple signs that are large, billboard signs that can direct traffic, I think would be more than adequate. I sold fireworks for a week there, and so I saw the lines and the drive-up situation, and I know exactly what Mr. Didier is speaking about. And that traffic line, actually, you would be able to get more cars lined up and out of the road if you did put it on another part of the building. And so there's no, really, it seems like it's being blown out of proportion as far as just simply moving it. Also, I wanted to just refer one other thing in the last discussion or last comment that I made, because it was implied that I called our commissioners cowards. I simply said that that's what it appeared to be. Also, I looked up what Commissioner Peck was stating, that a discussion is an action. And I would like to know what RCW he's talking about, because when I looked it up, it said, no, a discussion is not an action. It's not even defined in the Open Meetings Act. So having a discussion is not an action. An action is something that results as in a vote. So I was just curious why our county attorney did not correct him on that, but he seems to correct everything else. So I just wanted to make that point. Thank you. Bye.
Thank you for your comment. Good morning. Is this Anna?
Yes, this is Anna.
Hi, Anna. This is Keith Johnson. You have the floor.
Hi.
You have the floor for 3 minutes for your comments. Please go ahead.
Thank you, Mr. Johnson. On regards to your search for a PR firm, communications firm, I would like to also encourage you to, for one of the parameters that you're looking for, is for this agency to have bilingual staff, given the population that we have, and it is very important that all the communication that goes out is sent out bilingual, and they have that capacity. That is my comment today.
Okay, thank you.
Thank you. Goodbye.
We have one more caller on the line, Mr. Chairman.
Thank you.
Good morning. Is this Mr. Knudsen?
No, this is Mr. Knudsen, sir.
Okay.
But my name is unique and it's often mispronounced, but that's who I am.
Please go ahead.
Yes, there is a technology out there. I've been a beneficiary of it during this condition that we're living through. where people in remote locations can subscribe, and it's free, to things like GoToMeeting.com. There are others. Zoom is another one that's good, where you could have as many people who wanted to log into that application, and then we could have some of the things that we're missing in this meeting right now. I like to be able to watch the body position, the facial expression when people give testimony and make comments, so that I can judge the validity of the veracity of their statements. We're being denied that in this meeting, and I think that's aberrant, not useful to the public. Well, I'd like to make that recommendation that in future meetings, we utilize some of the vast technology at our disposal to be able to more closely approximate an in-person conversation with those officials that we've elected to govern our county.
Okay, thank you. That's helpful information. I appreciate that.
Yeah, I appreciate you gentlemen. You perform a vital service to the community. Thank you.
Thanks. Have a good day.
Anything else, Keith?
Looks like we have one more.
Okay.
Calls are starting to come in. Good morning. This is the Franklin County Commissioners Board meeting. I didn't catch your name.
I'm sorry, this is Ana Ruiz again, Ana Ruiz Peralta.
All right, Anna, go ahead.
Regarding the comment that the gentleman made before me, I agree with him. It is very useful and important for to see the commissioners, and that we have that technology. You know, I know Zoom is not as safe, but there's other ways that you can have a video conferencing capacity, and also we can still participate.
Okay, thank you.
And I know the city of Pasco is doing that, and we're able to see our council members and women in video as well when they participate. And they have the same capacity for the school district. So I think it would be good for all of us to, and I think it will be more beneficial for the public to see our commissioners work in a video capacity following the governor's orders. Thank you.
All right, thank you very much.
Thank you. Bye-bye.
Okay, Commissioner, I believe that's all of the current telephone called in.
All right. Thank you.
Chairman Cook, Chairman Cook, this is Sean Sant.
Yes.
It was raised up, and I just want to make sure, I'm not sure if the board had a question regarding Open Meetings Act or what constitutes action, but I think for the benefit of the board and the public, since it was asked, I figured I would just go ahead and cite the RCW. It's RCW 42.30.020, paragraph 3, defines action. Action means the transaction of the official business of a public agency by a governing body, including but not limited to receipt of public testimony, deliberations, discussions, considerations, reviews, evaluations, and final actions. So a meeting is defined as means meetings at which action is taken. So any meeting where there are discussions by the board, where there's a quorum, that would fall under action. So I just want to make sure if there was any doubt that having a scheduled board meeting with the quorum of the board, that is official business and it falls under the OPMA. Just wanted to make sure that was clear for everybody.
Thanks for that understanding. And so often it's people aren't really used to reading RCWs or knowing how to find RCWs. So thank you for keeping us up there. Anything further, Keith, on the phone?
Not at this time.
Okay, with that, it's bringing us to the end of the agenda. Is there anything for the good of the board, commissioners?
Mr. Chairman, this is Commissioner Didier.
Yes.
And I did, when I got back to my office here, I did look up the email that Sean sent to me. But I would like to request that this be sent a little earlier than 8:58 a.m. when we start at 9.
Yeah, agreed.
Thank you.
And again, I appreciate that, Commissioner Didier, and I just wanted to make sure you had the documents. I typically don't send the board the entirety of all of our research and review, but that's something that we've obviously based our opinion on previously. So, thank you.
So, Mr. Chairman, Commissioner Peck,
Yes.
want to thank Mr. Sant for clarifying that discussions by a quorum are in fact actions. It is difficult sometimes when people call in and allege that we've misrepresented the law, and rather than get into a back and forth with them in the interest of everybody, sometimes we just have to defer and hope that people listening don't take it as gospel when sometimes it's not accurate. So that's a particularly important distinction. I won't get into all the reasons why, but I appreciate his clarification. The other item I wanted to mention this morning is, if you have not seen it, I'd like folks to be aware that Yakima County was served with a lawsuit yesterday by One America and 4 other individual plaintiffs, and they are being sued for their voting process, which is identical to the one that we use, which is described as an at-large system with countywide voting in the general election. The claim is that it dilutes Latin votes, and I want to point out, as I did back when I was trying to encourage the board to redistrict, that any non-compliance with the law or being out of compliance with the law with respect to your district boundaries, or anything that would support a claim of disenfranchisement, which is the point I was trying to make, makes us vulnerable for a lawsuit. And I'm not going to take an opinion on the suit against Yakima County. Obviously, that wouldn't be appropriate, but I will tell you that I think the chances of it being us instead of Yakima County were 50-50, or perhaps chances of us being the ones in the suit were even greater. And I would encourage us, whenever people feel like the timing is appropriate, to remember that we're still vulnerable to a suit, and it wouldn't be all that difficult for us to be added to this mess. So for those of you who thought that there were other motives associated with trying to redistrict, take a look at this lawsuit, and I think you'll understand exactly the mess I was trying to keep us out of. Thank you.
Mr. Chairman?
Yes.
I would like to note that down in Colorado, where another blue state governor is, there's a county down there with 5 commissioners and a PA and an administrator and a sheriff that voted to open up for full business. They were threatened to be sued. They said, okay, sue us. They opened up all their businesses for business. No lawsuit came. Then they were told that they were going to be held back on the CARES Act money. And I said, that's okay, we don't want it. That wasn't held back either. They got their CARES Act money. I don't have that county's name in front of me, but this is a county that's standing up against this actions by an out of control governor. And I encourage that we take that same step and stand for the people of our county, where everybody is created and given equal fairness as far as opening businesses, where the private retail businesses that only have 15% capacity, 30-minute shopping time, when we got the big box stores, there's no stipulations held on those. The last thing I'd like to do is, even though we have differences, I would like to wish Chairman Cook a happy birthday.
Yeah, thank you. So, anything else for the good of the board? Either one
Nothing
of
from
you.
me, thank you.
Clint?
I'm good, thank you.
All right. Keith?
No, thanks. I'm good.
Karen?
I'm good. Happy birthday.
All right. Well, thanks, everybody. With that, we are adjourned. Thank you.